We have a word for shooting to kill in a civilian conflict. That word is murder. If you own a firearm for the purpose of defending yourself and your loved ones, it is vitally important that you understand the laws and your responsibilities concerning the use of deadly force. Now, I'm not a lawyer, and this is not legal advice, but a recent exchange made me realize that some gun owners have misconceptions concerning their rights and responsibilities. With some variations in wording and subtleties, the standard for justification of the use of deadly force is the same in all 50 states. When a reasonable person would believe themselves or another is in imminent and otherwise unavoidable danger of death or grave bodily harm, then the use of deadly force is justified to prevent that attack. Whether or not this standard was met will be judged on 3 criteria: ability, opportunity, and jeopardy. In other words, the killer must have the power to kill or cripple, be immediately capable of employing that power, and must act in a manner that a reasonable and prudent person would assume it was his intent to kill or cripple. Now, even if these standards are initially met, if they cease to be met during the conflict, for instance, if the assailant is incapacitated to the degree that he loses ability, then the continued use of deadly force is not justified under the law. So if we shouldn't shoot to kill, am I saying we should shoot to wound? Should we target the leg, the shoulder, the foot? Absolutely not. Any time you point a gun at another person and pull the trigger, you're employing deadly force, and the death of that person is a distinct possibility. Whether you target the leg or the chest, you must justify that use of deadly force to the same standard. But in targeting the extremities, you're much less likely to stop the threat before they do you harm. Now, shooting to wound is a concept bolstered by Hollywood. In reality, wounds to the extremities often prove fatal, and a moving arm or leg is an unreasonably difficult target. So if we're not to shoot to kill or to wound, what do? Simple. We shoot to stop the threat. Now, it may seem like a subtle difference, but it's a vitally important one. You see, the initial action between shooting to kill and shooting to stop may not be any different. We aim center of mass, and we keep pulling the trigger until they no longer pose an immediate threat. Now, this may result in the death of the assailant, but death is not the goal. And if we keep shooting after there is no longer an immediate threat, whether due to incapacitation, retreat, surrender, or whatever, then murder is the appropriate charge under the law. Defense of self and others is not about justice. It's not about revenge. And it's certainly not about pride. It's about keeping yourself and your loved ones safe. Now, before you chime in with comments like, if you kill the perp, there will only be one side of the story, or if they die, there will be no one to press charges or sue, go read In the Gravest Extreme. The state will press charges. The family will sue. And with rare exception, your life will be much, much harder if the assailant dies. Now, of course, all that's secondary. None of it matters if you die. Study. Train. Know your rights and responsibilities under the law. And if you ever have to employ deadly force to save the life of yourself or a loved one, shoot center of mass and do whatever you have to do to stop the threat. No less, no more.